Hello.
I'm Christopher Badger.
And I'm Mark Davies.
We're barristers at Six Pump Court and would like to welcome you back to the Environmental Law News podcast, brought to you in association with LexisNexis.
Thanks, Chris. Now, in this podcast, we'll be looking at the record fine imposed on Southern Water, helicopters near coma sites, and the potential for the precautionary principle to be revisited.
So first up, Southern Water, who were fined £90 million in Canterbury Crown Court.
Yes, and quite unsurprisingly, a lot has already been written and said about this case. So we thought we would consider the outcome in the context of the development of the sentencing guideline and the intention of the Sentencing Council when the guideline was first introduced.
Now, when the environmental guideline was first published in a draft format, water companies responding to the consultation at the time argued that statutory undertakers, such as themselves, should be recognised in a unique category, owing to their responsibilities in providing a service to the public, the scale of their operations, and the detailed regulatory landscape to which they are subject. The water companies considered that their responsibility for a network of sewers measuring over 300,000 kilometres and susceptible to damage from third parties meant that they would be subject to an unfair amount of punishment. In economic terms, the water companies argued that fines would not have a deterrent effect, as prices and investment plans are already subject to agreement by the regulators, and that substantial financial penalties could impact on their ability to improve the system for the public and environmental conditions generally.
Yes, and as all of our listeners will no doubt be aware, that argument was roundly rejected by the Sentencing Council. Whilst the Council agreed that the impact of a fine on an offender's ability to improve conditions was a relevant factor that a court could take into account in determining sentence, the Council did not consider that water companies were a special case. Rather, the Council stated that water companies are profit-making organisations with shareholders and have a choice whether to pay fines from profit rather than service delivery funding. Nor did the Council consider that water companies would be impervious to the economic deterrent of a fine. And further, the Council emphasised that the guideline is constructed in such a way to ensure that lower culpability results in lower penalties. As such, where an offender genuinely lacks fault for an incident, the fine will reflect this accordingly.
Culpability, therefore, is key when considering the level of penalty for an organisation such as Southern Water. In this case, the company was sentenced for 51 counts, covering 6,971 illegal spills from 17 sites in Hampshire, Kent and West Sussex between 2010 and 2015. Following the sentencing hearing that lasted 5 days, the sentencing judge, Mr. Justice Johnson, concluded that the offences had been committed deliberately by Southern Water's board of directors at the time, motivated, according to a report by the BBC, by a desire to focus the company's attention on those metrics that increase its income, disregarding the company's wider compliance obligations. The judge also found that the offences were aggravated by the company's previous persistent pollution of the environment over very many years.
Indeed, and back in June 2019, Ofwat had already given notice of an intention to issue Southern Water with a financial penalty amounting to £37.7 million, reduced exceptionally to £3 million for significant breaches of its licence conditions and statutory duties. Now, this was on the basis that Southern Water undertook to repay to customers approximately £123 million over a 5-year period. As part of the notice, Ofwat stated, and it's paragraph 4.56 for anyone who wants to look it up, that senior management within the Wastewater Operations Division colluded to conceal the actual performance of wastewater treatment works. A culture of data manipulation was the norm and was accepted by staff across the division.
Now, we don't know how Ofwat's penalty was taken into account by the court, given that it appears to have covered a very similar period of time, or how the clear levels of cooperation by Southern Water into the Ofwat investigation reflected in the case taken by the Environment Agency. It is understood that investigations into other events after 2015 continue. But we also know that Southern Water has stated that it will be shareholders that bear the cost of the fine, as foreshadowed by the Sentencing Council.
But the conclusion that the board at the time deliberately committed a criminal offence is extraordinary. That goes so far beyond the concerns that were raised by the water industry at the time that the guideline was originally published. And it makes it clear why the guideline should be of general application rather than categorising some organisations as a special case for which there should be some sort of form of exception or carve-out. But anyway, moving on and second up, tell me, Chris, what's all this about helicopters and coma sites?
So this is the recent decision of the Planning Court of Valero Logistics UK Ltd against Plymouth City Council. It's an important case for confirming the extent to which a local authority can rely upon another regulator when regimes overlap. It is still necessary that the council is satisfied that a site will be regulated appropriately, and it cannot just say, leave it all to the Environment Agency. In Valero, the applicants had sought planning permission for a commercial heliport near to fuel depots that were regulated under the control of major accident hazards regulations, because they handled and stored highly flammable fuels in above-ground tanks. You therefore had the unusual spectacle of local councillors being asked to judge the wisdom of building a heliport and having to consider the risks of an accident arising from low-flying helicopters. Whilst this might have a low probability, and indeed were assessed at 1 in a billion, its consequences could be catastrophic.
It's certainly not your usual planning application, rather different from the usual application for a late-night kebab shop.
Exactly. Whilst the council did impose planning conditions to restrict the number of movements and the permitted flight paths, the main reliance was placed on the requirement to satisfy the Civil Aviation Authority that the helicopter use was safe. This was particularly so, given that the site had a previous unregulated and unrestricted domestic helicopter use. The fuel storage operators argued that the council had conspicuously failed to engage with the scale of the risk posed to their coma sites.
And what did the planning court decide?
Well, the court considered that this was a question left to the reasonable judgment of the public authority, and that the evidence showed that the council had understood that it was ultimately a matter of planning judgment for it to make, and not for the CAA or the HSE, as to whether the risks and mitigation measures were acceptable, and the new heliport should be given permission.
Fascinating. So, whilst this case may not make new law, it does confirm that the stage where the real effort needs to be made, where in such cases contentious technical issues arise, is actually at the application stage and not in any future legal challenge.
Precisely. I, for one, have a lot of sympathy for the burden this kind of application can place on lay councillors, and it's a salutary reminder that environmental matters, whether in planning or litigation or so on, often turn on highly technical information, which is often complex. In some instances, I think that professional judges are hardly better placed. One has to wonder if the calls for experts to sit with tribunals will continue to grow as environmental matters take centre stage. Finally, is the precautionary principle about to be reconsidered?
Well, if I may, historically, regulation has sometimes stifled innovation. Some of the current regulatory standards inherited from the EU are based on an overly restrictive interpretation of the precautionary principle.
That's a fairly bold statement, Mark.
They're not my words. They're actually from the newly published UK Innovation Strategy, produced by the Department for Business, Energy and Industrial Strategy. The document also provides a useful insight into what role the government considers proportionality has to play in the current Environment Bill.
Ah, yes, the currently elusive policy statement that will interpret the relevant environmental principles and explain how ministers should proportionately apply those principles when making policy.
Yes, and it may be that the relevant environmental principles will face some reconsideration. After praising the outcomes that can be generated from a correct proportionate application of the principle, the strategy goes on to state, the precautionary principle can be interpreted in ways that produce more harm than good. In some cases, the precautionary principle has become a policy of blocking all potential harms, even a possibility of harm, without a balanced analysis of likely benefits.
And does the strategy attempt to justify this assertion?
Well, The strategy doesn't attempt to resolve how innovation and equivalence may interact, nor expand on how proportionality in a regulatory context may be redefined. It doesn't address previous attempts to consider the role of regulation, for example, the McCrory Review or the Better Regulation Framework. It does refer to the example of genetically modified crops and the lack of any significant adoption of GM crops in the EU, but doesn't give any further examples of how the UK has had its hands tied behind its back by EU law.
And so, are there any conclusions on the precautionary principle that are laid out?
No. The strategy continues, we will consult on how regulation can ensure that the UK is well placed to extract the best value from innovation, including on the need for and benefit of a new proportionality principle for regulation.
So, Mark, is the subtext that the government considers that environmental principles may hinder innovation?
Well, to quote again, without risk, there is no innovation. Key to the strategy is risk management, unlocking skills and investment, as well as providing strategic direction to tackle the current challenges as the government seeks to build back better. The forthcoming statement on environmental principles, due to accompany the Environment Bill, will therefore make for interesting reading if the government is to try and rebalance caution and environmental risk in the context of proportionality and the need for innovation.
Thank you for tuning in for this Environment Law News podcast. For more information on any of these stories, or if you'd like to discuss any of the topics raised in more detail, please contact Six Pump Court on 0207 797 8400, asking for either Christopher Badger or Mark Davies, or contact our colleagues at LexisNexis in the PSL Environment team.